Who may exercise the power of eminent domain? The Congress, and by delegation, the President, administrative bodies, local government units, even private enterprises performing public services. Local government units have no inherent power of eminent domain. They can exercise the power only when expressly authorized by the legislature. Section 19 of the Local Government Code confers such power to local governments, but the power is not absolute. It is subject to statutory requirements. From the case of Masikip versus City of Pasig. In the case of Lagkaw versus Judge Labra, the grant of the power of eminent domain to local government units under RA 7160 cannot be understood as equal to the pervasive and all-encompassing power vested in the legislative branch of government. The power of eminent domain must, by enabling law, be delegated to local governments by the national legislature, and thus can only be as broad or confined as the real authority would want it to be. From the case of Republic versus CA 2002. The exercise of the right of eminent domain, whether directly by the state or by its authorized agents, is necessarily in derogation of private rights. Hence, strict construction will be made against the agency exercising the power. In the present case, the respondent failed to prove that before it filed its complaint, it made a written, definite, and valid offer to acquire the property as required under Section 19 RA 7160, the case of Jesus is Lord Christian School Foundation versus Municipality of Pasig 2005. The exercise of the power of eminent domain is clearly superior to the final and executory judgment rendered by the court in an ejectment case, the case of Philstream International Incorporated versus CA. In Iron and Steel Authority versus CA, it was held that when the statutory life of the Iron and Steel Authority, ISA, and non-incorporated entity of the government expired in 1988, its powers and functions, as well as its assets and liabilities, reverted to and were reassumed by the Republic of the Philippines, in the absence of any special provision of law specifying some other disposition thereof. Accordingly, the Republic may be substituted as a party plaintiff in the expropriation proceedings originally instituted by ISA. In San Roque Realty versus Republic, the Supreme Court said that time and again, we have declared that eminent domain cases are to be strictly construed against the expropriator. If the Republic has actually made full payment of just compensation, in the ordinary course of things, it would have led to the cancellation of the title, or at least annotation of lien in favor of the government on the certificate of title. Thus, while the general rule is that the state cannot be put in estopel or laches by the mistakes or errors of its officials or agents, this rule, however, admits of exceptions, one of which is when the strict application of the rule will defeat the effectiveness of a policy adopted to protect the public, such as the torrents system. The exercise of the power of eminent domain. There should be necessity. When the power is exercised by the legislature, the question of necessity is generally a political question. From the case of Municipality of Mikawayan, Bulacan versus IAC. But when the exercise by a delegate, the determination of whether there is genuine necessity for the exercise is a justiciable question. From the case of Republic versus La Orden de Po Benedictos. The issue of the necessity of the expropriation is a matter properly addressed to the RTC in the course of expropriation proceedings. If the property owner objects to the necessity of the takeover, he should say so in his answer to the complaint. The RTC has the power to inquire into the legality of the exercise of the right of eminent domain and to determine whether there is a genuine necessity for it. From the case of Bardillon versus Barangay Masili of Calamba, Laguna, 2003. The foundation of the right to exercise eminent domain is genuine necessity, and that necessity must be of public character. Government may not capriciously or arbitrarily choose which private property should be expropriated. In this case, there was no showing at all why the petitioner's property was singled out for expropriation by the city ordinance, or what necessity impelled the particular choice or selection. Order number 1843 stated no reason for the choice of petitioner's property as the site of a socialized housing project. From the case of Lagkaw versus Judge Labra. There should be necessity. Ang requisite is necessity. Second requisite is private property. Private property already devoted to public use cannot be expropriated by a delegate of legislature acting under a general grant of authority. From the case of City of Manila versus Chinese community. All private property capable of ownership may be expropriated except money and choses in action. Even services may be subject to eminent domain, from the case of Republic versus PLDT. Ang third nga requisite is taking in the constitutional sense. What is taking in the constitutional sense? Taking in the constitutional sense may include trespass without actual eviction of the owner, material impairment of the value of the property, or prevention of the ordinary uses for which the property was intended. In Ayala de Rojas versus City of Manila, the imposition of an easement of a 3-meter strip on the plaintiff's property was considered taking. In People versus Fajardo, a municipal ordinance prohibiting a building which would impair the view of the plaza from the highway was likewise considered taking. In these cases, it was held that the property owner was entitled to the payment of just compensation. So generally, ang taking in the constitutional sense means 1. Trespass without actual eviction of the owner. 2. Material impairment of the value of the property. And 3. Prevention of the ordinary uses for which the property was intended. In National Power Corporation versus Gutierrez, the court said that the exercise of the power of eminent domain does not always result in taking or appropriation of title of the expropriated property. It may only result in the imposition of a burden upon the owner of the condemned property without loss of title or possession. In this case, while it is true that the plaintiff is only after a right-of-way easement, it nevertheless perpetually deprives the defendants of their property rights, proprietary rights, as manifested by the imposition by the plaintiff upon the defendants that below said transmission lines, no plant higher than 3 meters is allowed. Besides, the high-tension current conveyed by the transmission lines poses continuing danger to life and limb. In the case of Republic versus Castelvi, the Supreme Court enumerated the following requisites for a valid taking. 1. The expropriator must enter a private property. 2. Entry must be for more than a momentary period. 3. Entry must be under warrant or color of authority. 4. Property must be devoted to public use or otherwise informally appropriated or injuriously affected. And 5. Utilization of the property must be in such a way as to oust the owner and deprive him of beneficial enjoyment of the property. Where there is taking in the constitutional sense, the property owner need not file a claim for just compensation with the Commission on Audit. He may go directly to the court to demand payment. The case of Amiglable versus Cuenca. The owner of the property can recover possession of the property from squatters, even if he agreed to transfer the property to the government until the transfer is consummated or the expropriation case is filed. From the case of Villarma versus CA. Ang fourth requisite for the exercise of eminent domain is public use. The concept of public use. As a requirement for eminent domain, public use is the general concept of meeting public need for public exigency. It is not confined to the actual use by the public in its traditional sense. The idea that public use is strictly limited to clear cases of use by the public has been abandoned. The term public use has now been held to be synonymous with public interest, public benefit, public welfare, and public convenience. From the case of Reyes versus National Housing Authority, 2003. Public use requirement for the valid exercise of the power of eminent domain is a flexible and evolving concept influenced by changing conditions. It is accurate to say that at present, whatever may be beneficially employed for the general welfare satisfies the requirement of public use. From the case of Estate of Salud Jimenez versus Pesa, the meaning of public use has also been broadened to cover uses which, while not directly available to the public, redounded to their indirect advantage or benefit. From the case of heirs of Juan Ordona versus Reyes. Thus, in Fieldstream International Incorporated versus Court of Appeals, the fact that the property is less than something hectare and that only a few could actually benefit from the expropriation does not diminish its public use character, inasmuch as public use now includes the broadened notion of indirect benefit or advantage, including in particular urban land reform and housing. The practical reality that greater benefit may be derived from by Iglesia Ni Cristo members that most others could well be true, but such peculiar advantage still remains merely incidental and secondary in nature, that only a few would actually benefit from the expropriation of the property does not necessarily diminish the essence and character of public use. The case of Manuska versus Court of Appeals. When exercised by a local government unit, by the express legislative authority granted by the Congress in Section 19 RA 7160, the local government units may expropriate private property for public use or purpose or welfare for the benefit of the poor and the landless. In Muday versus Court of Appeals, the Supreme Court held the Sangguniang Panlalawigan of Agusan del Sur was without authority to disapprove Banawan Municipal Resolution number 4389 because clearly the municipality of Banawan has the authority to exercise the power of eminent domain and its sangguniang bayan the capacity to promulgate the asile resolution. However, note that in the municipality of Parañaque versus VM Realty Corporation, the Supreme Court declared that there was lack of compliance of Section 19 RA 7160, where the municipal mayor filed a complaint for eminent domain over two parcels of land on the strength of a resolution passed by the Sangguniang Bayan because what is required by law is an ordinance. In Lagcao versus Judge Labra, the Supreme Court said that condemnation of private lands in an irrational or piecemeal fashion, or the random expropriation of small lots to accommodate no more than a few tenants or squatters, is certainly not the condemnation for public use contemplated by the Constitution. This deprives a citizen of his property for the convenience of a few without perceptible benefit to the public. Moreover, prior to the passage of Ordinance Number 1843, there was no evidence of valid and definite offer to buy the petitioner's properties as required by Section 19 RA 7160. Ang fifth na requisite for the valid exercise of eminent domain is just compensation. The concept of just compensation. The full and fair equivalent of the property taken, it is the fair market value of the property. It is settled that the market value of the property is the sum of money a person desirous but not compelled to buy and an owner willing but not compelled to sell would agree on a price to be given and received therefore. The aforementioned rule, however, is modified where only a part of the certain property is expropriated. In such case, the owner is not restricted to pay the market value, not restricted to the payment of the market value of the portion actually taken. In addition to the market value of the portion taken, he is also entitled to payment of consequential damages, if any, to the remaining part of the property. At the same time, from the total compensation must be deducted the value of the consequential benefits, if any, provided the consequential benefits shall not exceed consequential damages. From the case of National Power Corporation versus Spouses Chong, 2003. Just compensation means not only the correct amount to be paid to the owner of the land, but also payment within a reasonable time from its taking. The case of Islaban versus De Honorio, 2001. Tax credit given to commercial establishments for the discount enjoyed by senior citizens pursuant to RA 7432 or the Senior Citizens Act is a form of just compensation for private property taken by the state for public use, since the privilege enjoyed by senior citizens does not come directly from the state but from the private establishments concerned. Commissioner of Internal Revenue versus Central Luzon Drug Corporation, Commissioner of Internal Revenue versus Bicolandia Drug Corporation, 2006.